Greg and Michael are sitting in a courtroom with their lawyers. At this point, the judge is cranky. He had to sit through days of non-stop bickering about a Lamborghini. "I'm ready to make my ruling," the judge says. After a night of drinking, Greg sold Michael his Lamborghini using a paper napkin contract. All it took was $500. Greg tried to destroy the evidence by tearing up the napkin. What Greg didn't realize was that Michael took a picture of the napkin already. Once the contract is good, there are other ways to prove it existed other than providing the original contract. The picture of the contract is an acceptable copy. Besides, you don't get to use the law as a defense by committing fraud. The judge looks down at Greg and he says, "You lose." Greg lost because of something called the Statute of Frauds. It's a law that basically says, if the deal is big enough and you didn't write it down, it never happened. Now, let's talk about my legs. Get your mind out of the gutter. It's an acronym that will help you remember which contracts need to be in writing. M stands for marriage. Promises made in consideration of marriage, such as prenuptial agreements, must be in writing. Y stands for year. Contracts that can't be completed within 1 year, such as a 2-year employment contract. L stands for land. Any contract involving the sale of land or a lease lasting longer than 1 year must be in writing. E stands for estate. A promise by an executor to pay a deceased person's debt from their own personal funds and not the estate's. G stands for goods. The sale of goods priced at $500 or more. A car is a good, so this rule applies to Greg's Lamborghini. S stands for surety, a promise to pay the debt of another person, such as a cosigner. So, have you ever made a bad contract with a friend that you tried to get out of? If so, I want to hear your stories. Please don't forget to like and subscribe.